Hello everybody, and welcome to the third and final webinar in our series of webinars looking at recent developments in relation to property disputes. I'm joined today by my colleague Elaine Brailsford, and the focus today is going to be on interpretation of property contracts and implied terms in property contracts. We're going to begin by looking at the Court's approach to interpretation of contracts in light of recent case law, and in particular the principle of applying commercial common sense to determine the meaning. And in that regard, we're going to look in particular at two Supreme Court decisions, Rainy Sky SA against Cookman Bank and the recent case of Arnold against Britton, as well as looking at some recent Scottish case law involving dilapidations, which have involved this issue of commercial common sense. We're also going to look then at the principles that apply in relation to implying a term into the contract, and in that regard we're going to be looking at the recent Supreme Court decision in Marks & Spencer PLC against BNP Paribas Securities Services Trust Company, Jersey Limited. So, I'm going to begin just by looking at the Court's approach to interpretation of contracts. I think it's fair to say that traditionally in Scotland the focus was very much on the words on the page, and the courts would very much look to give effect to the natural meaning of those words. But there have been a fair number of cases over the years, particularly judgments in the House of Lords and more recently the Supreme Court, in which the principles which apply have evolved over time, and in which the courts are now taking a much more contextual approach to interpretation, looking at relevant surrounding circumstances, and more recently taking into account what meanings which accord with commercial common sense. Now, this culminated in 2011 in the case of Rainy Sky against Cookman Bank, in which the approach that was to be taken and the principles which applied were not really in dispute. The Court summarised those as set out on the slide there, that the ultimate aim for the Court is to determine what the parties meant by the language used, that it involves ascertaining what a reasonable person would have understood the parties to have meant, and that a reasonable person is one who has all the background knowledge which would reasonably have been available to the parties in the situation in which they were in at the time the contract was made. So far so good, but the issue which was considered in particular in Rainy Sky against Cookman Bank was the role to be played by considerations of business common sense, as they put it in that case, in determining what the parties meant. Now, the Court did state that where the parties have used unambiguous language, and this was something that the case law had always made clear, then the Court must apply that language. But the Court noted that the language used by the parties will often have more than one meaning. Now, it had been thought by some that unless the most natural meaning of the words produced a result that was so extreme as to suggest that it was unintended, then the Court had to give effect to that meaning. But the Court in Rainy Sky made clear that actually the approach was different, and that if there was more than one possible interpretation, then the Court was entitled to prefer the interpretation which is consistent with business common sense, and to reject the other. Now, that approach, which is applied in Rainy Sky, has been followed in many cases in England and also in Scotland since. And the approach arguably reached its high point in the case in Scotland in the Inner House, the Appeal Court in the Court of Session of Grove Investments Limited against Cape Building Products Limited, which was a dilapidations case, and it was a judgment that was issued in 2014. Now, the issue in that case was whether the tenant was obliged to pay whether the landlord was entitled to payment of the total value of the schedule of dilapidations, regardless of whether it intended to carry out the works. In terms of the relevant clause, the tenant was obliged to pay to the landlords the total value of the schedule of dilapidations prepared by the landlords. Now, the landlord argued that what this was a payment clause, not a damages clause, and that it provided a contractual entitlement to payment of the sum specified in the schedule of dilapidations, regardless of whether the landlord was actually going to carry out the works. The tenant argued that, properly interpreted, it was effectively a restatement of the common law, that it provided for damages for losses suffered by the landlord as a result of the tenant's failure to carry out the works. The court, applying the approach that the Supreme Court had taken in Rainy Sky, concluded that both parties' interpretations were possible, so it had to decide which accorded best with commercial common sense. And it ended up preferring the tenant's interpretation, that effectively the clause provided a damages remedy for losses suffered rather than a contractual entitlement to payment. Why was that? Well, the court considered that the function of the clause was to provide the landlord with rights in respect of breach of contract, and that the most natural way of providing a remedy was to compensate the landlord for losses as a result of the breach. Where the landlord intended to reinstate the premises in full, the tenant's interpretation provided full recovery for the cost of reinstatement. However, where the landlord did not intend to reinstate in full, then the landlord's interpretation might result in recovery of more than the actual loss. So the level of recovery might be arbitrary and disproportionate and not related to any loss sustained, and this, the court considered, was contrary to commercial common sense. The tenant's interpretation, by contrast, provided full compensation to the landlord for loss ultimately suffered, and the court considered that that was in accordance with commercial common sense. Now, the court's approach in Grove was followed in a few cases subsequently, and in particular in two subsequent dilapidations cases, Asset Pension Trustees, at first instance, the judgment in which was issued in September 2014, and in Mapley Acquisition against the City of Edinburgh Council, the judgment in which was issued in March 2015. In June 2015, the Supreme Court issued its judgment in Arnold against Britton, and that case, as Elaine is going to go on to explain, provided further guidance in relation to the interpretation of contracts. And in December 2015, the decision in ATSIP at first instance was overturned on appeal, and as we will see, the decision in Arnold against Britton was certainly a factor in that, and arguably a very significant factor. But before we come on to talk about ATSIP, I'm going to hand over to Elaine, who's going to tell you all about Arnold against Britton.
Yes, well, Arnold against Britton was a Supreme Court case, and it was a dispute between the owner of a leisure park, which contained 91 chalets, and the tenants of 25 of those chalets. The issue in dispute was the interpretation of the service charge clauses in the leases. In terms of those clauses, the tenants were obliged to pay an annual sum for services which the landlord was obliged to provide, such as repair and maintenance for the whole leisure park. The relevant clause was not identical in each of the leases. There were slight variations, but a typical example of the clause is shown on the slide. To pay a proportionate part of the expenses and outgoings incurred by the lessor in the repair, maintenance, renewal and provision of services hereinafter set out, the yearly sum of £90 and value-added tax, if any, for the first year of the sum hereby granted, increasing thereafter by £10 per 100 for every subsequent year or part thereof. Now, the landlord argued that the clause obliged the tenants to pay a sum, initially £90, increasing at a compound rate by 10% a year, regardless of the cost of providing the services. And the tenants argued that the clause should be interpreted so that they were obliged to pay a proportion of the cost of providing the services, subject to a cap, that cap being £90 initially and increasing by 10% a year. In effect, their argument was that the words "up to" should be read into the clause before the words "the yearly sum of £90". Now, they contended that the landlord's interpretation would result in such increasingly absurd levels of service charge in the later years of the leases that it could not be right. By way of an example, under one of the leases granted in 1980, the service charge would be £550,000 by the year 2072, regardless of the cost of providing the services. The effect of the tenant's interpretation would be that the annual service charge would be dependent on the actual cost of providing the services. Now, the tenants were successful at first instance, but they lost on appeal to the High Court, and then in the Court of Appeal, they appealed to the Supreme Court. Now, the Supreme Court's judgment provides very important guidance regarding interpretation of contracts, particularly in relation to the application of commercial common sense, which we've heard Dan talk about. With reference to previous House of Lords and the Supreme Court case, which culminated in Rainy Sky, which dealt with contractual interpretation, Lord Neuberger, in the leading judgment, confirmed that when interpreting a contract, the Court is concerned to identify the intention of the parties by reference to what a reasonable person would have understood the parties to have meant by the language used in the contract, having regard to the background knowledge that would have been available to them. He stated that the Court does that by focusing on the meaning of the relevant words in their documentary, factual and commercial context, and that the meaning of the words has to be assessed in light of the following factors. Firstly, the natural and ordinary meaning of the clause. Secondly, any other relevant provisions of the contract. Thirdly, the overall purpose of the clause and the contract. Fourthly, the facts and circumstances known or assumed by the parties at the time the contract was entered into. And fifthly, commercial common sense. Lord Neuberger also noted that subjective evidence of any party's intention is to be disregarded. The party's intentions must be identified objectively. So in giving his judgment, Lord Neuberger emphasised a number of factors in relation to the Court's approach, particularly in relation to commercial common sense. He stated that commercial common sense should not be invoked to undervalue the importance of the language of the provision in question. The parties have control over the language used in a contract and must be taken to have focused on the issue covered by the provision when agreeing its wording. In addition, commercial common sense is not to be invoked retrospectively. It's only relevant to how matters would or could have been perceived at the date the contract was made. The mere fact that a contract, if interpreted according to its natural language, has worked out badly or even disastrously for one of the parties is not a reason for departing from the natural language. While commercial common sense is, as he put it, a very important factor to take into account, a court should be very slow to reject the natural meaning of a provision as correct simply because it appears to be a very imprudent term for one of the parties to have agreed. Applying the principles which Lord Neuberger discussed in his judgment, the Court dismissed the tenant's appeal by a majority of 4-1. The Court concluded that the natural meaning of the clause was clear. The first part of the clause required the tenants to pay an annual service to reimburse the landlord for providing the services. The second part identified how the service charge was to be calculated. It was to be a fixed sum with fixed annual increases. Now, the Supreme Court's judgment in this case emphasises the paramount importance of the words used in a contract and makes clear that there are limits to the extent to which commercial common sense can be invoked when interpreting the contract. If the natural meaning of the words is clear, the Court will give effect to them. If that produces what might seem to be an unfair result for one of the parties, so be it. The Court will not rewrite a contract to produce what it considers to be a common sense outcome. While the judgment hasn't changed the law as regards interpretation of contracts, the guidance it provides as regards the approach to be taken is hugely significant, and it's already had an impact in subsequent cases, most notably in Scotland, in the AXIT Pension Trustees case, which Dan is now going to explain.
Thanks, Elaine. As I mentioned earlier, AXIT Pension Trustees was decided at first instance in September 2014, following on from Grove, but before, just under a year before the Supreme Court issued its judgment in Arnold against Britton. The appeal in AXIT was heard after the Supreme Court judgment in Arnold against Britton was issued, and the appeal court's decision was issued in December 2015. As in Grove, the issue was whether the landlord was entitled to recover the total cost of the works in the schedule of dilapidations, regardless of whether it intended to carry out the works. And the specific wording is on the slide there. The tenant was obliged to pay to the landlord at the determination date a sum equal to the amount required to put the leased subjects into good and substantial repair. A very similar clause to the one that was an issue in Grove, and as I mentioned earlier, the judge at first instance reached ultimately the same conclusion as was reached in Grove, applying this principle of which interpretation accorded best with commercial common sense. The tenants in ATSEP at first instance and on appeal accepted that one possible meaning was the meaning which the landlords were arguing for, i.e. that it was a payment clause, not a damages clause, and that the sum due was the repair costs, and the extent and whether and to what extent the subjects were worth less in capital terms were not relevant. The appeal court, however, disagreed with that and actually came to the view that the interpretation which was contended for by the landlords was the only natural and ordinary meaning to be given to the terms of the clause. The court said that to do otherwise and to entertain the meaning which was argued for by the tenants would do such violence to the clause, as they put it, as to produce an incomprehensible result, namely that despite wording which provides only for the sum due to be measured in terms of repair costs, and despite the requirement for the landlord to elect and notify, parties could be taken to have intended nothing more than that the landlord's claim be restricted to damages for breach of contract. The court considered that the words clearly indicated that the parties intended that if the subjects were not at termination in the condition in which they would have been if the tenant had complied with its repairing obligations, then the landlord was to be entitled to payment of a sum equal to the cost of bringing them up to that standard. Whether the landlord intended to carry out the works was not relevant. Now, as I say, it's a very similar clause to the clause that was issued in Grove, but a very different result. The appeal court in ATSEP did point out that whilst the clauses may be similar, they were not identical, and that there were significant differences in the wording between the clauses, so that the decision in Grove, as regards the particular clause that was an issue in that case, does still stand. However, the court also made some comments in relation to some of the observations that had been made by the court in Grove and which had clearly influenced the judge at first instance in ATSEP. Particularly, the court in general made the comment that the observations that had been made in Grove predated the guidance which had been provided by the Supreme Court in Arnold and must accordingly be regarded with an appropriate degree of caution. The court also pointed out, by reference to Arnold against Britton, that as Lord Hodge in his judgment had pointed out in that case, it is not legitimate to rewrite parties' agreements because it is unwise of one party to gamble on future outcomes. The question is not whether a reasonable tenant would have entered into the obligation. So, as we can see, a very different result. I think it's fair to say that the Supreme Court judgment in Arnold against Britton was clearly a significant factor, if not perhaps the defining factor in the appeal court overturning the decision in that SIP, bearing in mind that the court did point out some specific differences in the wording. But I think in general, it's fair to say that many of the considerations that the court applied in Grove do, as the appeal court said, have to be treated with some caution, and that Arnold against Britton is really the case that has to be taken as the guide to be used when it comes to applying commercial common sense. Now I'm going to turn to look at implied terms in property contracts, and Elaine is going to talk about the recent Supreme Court judgment in Marks & Spencer plc against BNP Paribas.
Yes, as Dan says, this is another recent Supreme Court case. It involved a tenant's break option in a lease. The break date fell between quarterly payment dates, and the issue in dispute was whether a term could be implied into the lease, entitling the tenant to recover a proportion of the rent paid in advance for the period after the break date. In terms of this particular lease, the rent was to be paid yearly and proportionately for any part of a year by equal quarterly instalments in advance on the usual quarter days. The break clause provided that the option to terminate the lease could be exercised by giving 6 months prior written notice to take effect on the 24th of January 2012. It also provided that the break would only take effect if no rent was outstanding on the break date and if a break premium was paid to the landlord by the break date. Now, the tenant served his break notice on the 7th of July 2011. Shortly before the 25th of December 2011, the tenant paid the rent that was due on that date for the quarter ending 24th March 2012. That ensured that there would be no outstanding rent on the break date. The break premium was paid on the 18th of January 2012. So as a result of the payment of the rent and the break premium, the break notice was effective and the lease terminated on the 24th of January 2012. The tenant then sought repayment of a proportion of the rent for the period from the 24th of January to the 24th of March, arguing that a term to that effect should be implied into the lease. Now, the tenant won at first instance, but lost in the Court of Appeal and appealed to the Supreme Court. While the Supreme Court judgment is important for landlords and tenants of commercial properties, its wider significance lies in the guidance given by the court on the principles which apply when a court is determining whether a term is to be implied into a contract. As in Arnold against Britton, the leading judgment was given by Lord Neuberger. As he noted, there are two types of implied term. The first is a term which is implied into a particular contract in light of the express terms of the contract, commercial common sense, and the facts known to both parties at the time the contract was made. The second type of implied term are those that are implied by law in certain types of contract. The M&S case concerned the first type of implied term. Now, drawing on previous case law involving implied terms, Lord Neuberger set out the general principles which apply. The key principle is that a term will only be implied if it is necessary to give business efficacy to the contract, or if it is so obvious that it goes without saying. Only one of those conditions needs to be satisfied, but as Lord Neuberger put it, it would be a rare case when only one of them was satisfied. In addition to those conditions, the proposed implied term must be capable of clear expression, and it must not contradict any expressed term of the contract. The proposed implied term must also be reasonable and equitable. As Lord Neuberger pointed out, however, if a term satisfied the other necessary conditions, it is hard to think that it would not be reasonable and equitable. However, just being reasonable and equitable is not itself sufficient. A term should not be implied into a detailed commercial contract merely because it appears fair, or merely because the court considers that the parties would have agreed it if it had been suggested to them. Those are necessary, but not sufficient, grounds for including a term. The other necessary conditions must be satisfied. As regards the question of whether a term is necessary to give business efficacy to the contract, Lord Neuberger commented that the test is not one of absolute necessity. It involves a value judgment, as the necessity is judged by reference to business efficacy. He considered that a more helpful way of expressing this condition may be that a term can only be implied if without the term the contract would lack commercial or practical coherence. In considering the general principles which apply, Lord Neuberger also made some significant comments in relation to the case of Attorney General of Belize against Belize Telecom. This was a Privy Council judgment of 2011, in which Lord Hoffman suggested that the process of implying terms into a contract was part of the process of interpretation of the contract. Lord Neuberger noted that the Belize Telecom case has been interpreted by some academic lawyers and judges as having changed the law, in particular by diluting the conditions which have to be satisfied before a term will be implied. He confirmed that there has been no such dilution of the necessary conditions, and the law remains unchanged following Belize Telecom. As regards Lord Hoffman's suggestion that the process of implying terms into a contract was part of the process of interpretation of the contract, Lord Neuberger made clear that interpreting the words used and implying additional words are different processes governed by different rules. While there is some overlap in the factors that are to be taken into account, that does not mean that the exercise of implication is part of the exercise of interpretation, let alone that they should be carried out at the same time. The question of whether a term is to be implied into a contract can only be considered after the express terms have been interpreted, not least because one of the conditions which must be satisfied is that the implied term does not contradict an express term. So turning back to the implied term proposed by Marks and Spencer, Lord Neuberger recognised that the term would be fair, in that the lease could be said to work unfairly without it. However, he also recognised that the lease was a very full and carefully considered contract, containing express obligations of the same nature as the proposed implied term, namely financial liabilities in connection with the tenant's break option. He considered that the proposed term would sit uneasily with those other express provisions. More significantly, he noted that part of the background against which the lease was agreed was that at common law in England, rent payable in advance was not apportionable. He stated that, save in a very clear case indeed, it would be wrong to attribute to a landlord and a tenant, particularly when they have entered into a full and professionally drafted lease, an intention that the tenant should receive an apportioned part of the rent payable and paid in advance, when the non-apportioned has been so long and clearly established. Accordingly, the court concluded that the term proposed by the tenant could not be implied, and that an express term would be required to entitle the tenant to the repayment sought. The fact that the absence of the implied term could lead to an unfair result, and in this case it was completely absurd. Conclusion.
Thanks, Elaine. So that almost brings us to a close. Up on the slide there are the citations for the cases that we've discussed today, in case anyone wants to have a look at them. If anyone has any questions, then please do type them into the chat box, and we'll see them, and we can hopefully pick up on one or two if anyone does have any questions. Before coming to that, I guess we'd make a few general comments about where we are in relation to interpretation of contracts and implied terms, particularly following Arnold against Britton and Marks and Spencer. I mean, I think what those two cases in particular underline is the importance of the words used by the parties when drafting the contract. And as Lord Neuberger pointed out, and as Elaine mentioned earlier, the parties have control over the words used when they're drafting the contract, and it's important that the parties exercise that control carefully to ensure that the words on the page are clear, because otherwise they may then find themselves in a dispute about what meaning might accord best with commercial common sense, and or they might find themselves in dispute about whether a term should be applied. And as can be seen from the M&S case, the test is fairly high in terms of whether a term should be implied. But I think what these cases do is provide an element of certainty or additional certainty that the court will look to apply the terms used by parties and will give effect to the natural meaning of the words used, provided that it is possible to do that. And it's only really where there is ambiguity that this principle of commercial common sense will come into play in terms of finding what is the most appropriate meaning, and it's only really where it is necessary that a term we've had one question come through which relates to the M&S case, and the question is whether rent in Scotland is apportionable, which is a good question. It's something that actually Elaine and I were looking into before the webinar, because clearly that was the the most significant factor, I think, in the court coming to the conclusion that the term proposed by M&S could not be implied in that case. Well, I think it's fair to say that the position in Scotland is not clear. The position in England is relatively clear as a result of the case law that was referred to by Lord Newburger in M&S. There have been suggestions in Scotland that the position is the same, and that rent payable in advance is not apportionable. But Elaine, you were talking to one of our property colleagues before this webinar who took a different view.
Yes, our property colleagues here have suggested that it has always been felt that it was an implied term that the rent would be apportioned, and that routinely landlords in Scotland do repay to tenants a proportion of the rent. And what they're now finding as a result of the M&S case is that new leases coming through are now containing a specific express provision about repayment of rent. But I mean, the old textbooks do talk about apportionability of rent in agricultural leases. I don't think rent is apportionable. There's a suggestion that in urban leases they are, but similarly I've seen councils council in Scotland giving a talk on which he suggests that it's not apportionable. So I think going forward, clearly, as our colleagues in the property department are doing, we'll be seeing express terms in all of these leases, and the same will be said, no doubt, with our colleagues south of the border following on this case.
Okay, well, there's been no further questions, and it's just gone 1:30. So all that remains, I think, is for me to say thank you for joining us for the webinar. I hope you found it useful. If anyone does have any follow-up questions that they want to ask, then please do get in touch. You'll receive by email a link to the slides and a recording of the webinar. And our contact details are on the slides there if you do want to get in touch with us. We're happy to answer any queries that you have. So thank you very much, and goodbye.